So now the question arises, when will a court hear evidence? When will there be need for the court to hear evidence? So the answer to this is that whenever there will be a factual dispute, like one party is saying something and the other party is negating it, then there will be a need for the court to hear evidence in order to get the idea that what fact is really true. When there is a dispute about a factual issue which must be resolved in order for the court to determine the legal consequences, then the court has the need to hear evidence. In criminal trials, the tribunal of fact, which is in the crown court, jury, and in magistrate court, the judges, has to reach a conclusion as to what happened in order to decide whether or not D is guilty. But it is rarely the case that every single essential fact is in dispute. Sometimes parties agree on facts. For example, in a domestic burglary case, the prosecution must prove that D entered the property as a trespasser and stole therein. But if the defense is alibi, like defense is saying that he was somewhere else, the accused person, it may not be disputed that there was a burglary. The only fact in dispute being who did it. Like that person is not negating that burglary happened or not. He's just saying that he wasn't there. When facts in a trial are not in dispute, then one of two things will happen. The party will make admissions as to the agreed facts to avoid necessity of calling evidence. They will make admissions that they agree on these facts. So then there will be no need to call evidence. The party wishing to establish the fact will present its evidence. The party which is saying something is true has to give evidence on the fact, and the other side, if it also does not challenge it and saying that it agrees to it, it will not need to have a cross examination on those facts, or it does not need to put contradictory evidence to those facts.